Hello, this is Fred Hopma, and in this video I will discuss the answers of assignment Legal 1B Public-Private Partnerships. Okay, this assignment started with a case, and the case reads as follows. Municipality A has adopted a land use plan for an area on the 1st of September 2019. The most important land use objective in the area is residential. Project developer Fondsbouw owns a large plot of land in the area. For this area, the land use objective is residential as well. Okay, this assignment has a total of 50 points to be given, and each question has a maximum of 10 points. Let's go to the question. The first question is, what does the adoption of the land use plan on September 1st, 2019 mean for Fondsbouw? Is the company obliged to start the realization of the houses that are indicated in the land use plan within a certain time frame? Let's take a look at the answer. The correct answer is no. The company, Fondsbouw, is not obliged to start realization. There is no obligation for landowners to implement a land use plan once it is adopted by the council. A land use plan that has been adopted by the municipal council is no guarantee for full realization of the intended urban area development within a certain time frame. Landowners, like Fondsbouw, are not obliged to implement a land use plan. That is, they are not obliged to realize the land use objectives for the lands. They are not obliged to apply for environmental permits to realize the land use plan. This is explained in the book Planning and Development Law in section 4.3, legally binding effects of a land use plan. Let's go to question 2. Fondsbouw is of the opinion that the municipality, when it adopted the land use plan, on a number of places laid down a density that is too high. Furthermore, the company is of the opinion that the parking ratio is too low. Fondsbouw is of the opinion that these elements of the land use plan will lead to a bad sale of the future houses it wants to develop in the area. The question is, can, now that the land use plan is adopted recently, anything be done about this? Yes, something can be done about this. Most likely is a deviation from the land use plan. In legal terminology, granting of an environmental permit for the use of land or constructions in conflict with the land use plan. This is one of the articles in the Environmental Licensing Act and explained in Planning and Development Law section 4.9 regarding deviation from a land use plan. This will only work if the municipality agrees to deviate. So for this to work, Fondsbouw has to convince the municipality that the land use plan needs to be changed on the topics like the parking ratio and density. Another possibility is to make a new land use plan for the area. Also, this will only work if the municipality agrees to do so. Each of both answers could be given points, 8 points and 6 points. However, the maximum number of points for this question is 10 points. So, yes, something can be done. The municipality has instruments to deviate from the land use plan or to adopt a new land use plan. Of course, it would have been better if the municipality had consulted Fondsbouw in advance and see if the municipality could agree with Fondsbouw. However, strictly spoken, the municipality has the power to unilaterally adopt a land use plan. However, the danger is that the land use plan will not be implemented if there is no real interest from the developers. There were some alternative answers that also were given points. First, once the land use plan has been adopted, interested parties have the right to appeal against the land use plan contents. Fondsbouw can be seen as an interested party as it is directly affected by the new land use plan. Hence, Fondsbouw has legal standing. This is correct in itself. 10 points would be given. Second, the developer can refrain from application for environmental permits for the proposed development of the plan. 2 points. In itself, this answer is correct, but it is not a real answer to the question what can be done about the unfavorable land use plan. The answer does not give any clue what can be done about the unfavorable land use plan. The answer misses that the municipality can change the land use plan by deviating from it via an environmental permit or by adopting a new land use plan. Again, it would have been better if both parties had consulted before the land use plan was adopted, because indeed both parties will need each other. The developer needs a favorable land use plan, and the municipality needs developers to realize the functions of the land use plan. There was a third answer that I saw, and it is, as the municipality and Fondsbouw depend on each other, they should enter into a PPP agreement. Well, I could not give any points for that answer because a PPP agreement in itself, a public-private partnership agreement, does not change the land use plan, which is what Fondsbouw needs. Go to the third question. Suppose that the land use plan remains unchanged. Fondsbouw hires architects to make designs for the houses, and once the sales brochures are ready and available, there are many protests from the citizens living in the neighborhood. They feel that the materials that will be used for the houses are ugly and do not match with the existing houses. Can these citizens legally do anything against the materials? And if so, what and when? Well, there are no procedures possible against the land use plan anymore. That stage has passed. The issue the citizens raise is an issue of aesthetics or external appearance. The test of a building design against aesthetics is a test in the framework of the environmental permit for building and construction. The citizens can raise their issue once Fondsbouw submitted an application for an environmental permit to build. They can appeal against environmental permit decisions with the court and with the Administrative Jurisdiction Division of the Council of State. Higher appeal. However, they will only be successful if they can demonstrate that the materials are in conflict with the policy document on external appearance. This policy document is adopted by the Municipal Council. All of this is explained in the book in sections 3.2.6 regarding legal protection and section 3.6 regarding regulations concerning external appearance. Many points could have been given for different parts of the answer. However, the maximum number of points that can be given is 10. Some students simply answered that the citizen can lodge appeal against the decision to grant the environmental permit and that this must be done within 6 weeks after granting the permit. It is correct that the citizen can lodge appeal. However, what is missing in this answer is that the citizens will only be successful if they can prove that the design is in conflict with the criteria of the policy document on external appearance, because the law says that applications for permits, as far as building aesthetics or external appearance is concerned, need to be tested against the policy document. Another alternative answer. The citizens can go to the open meetings of the External Appearance Committee, which advises the municipal executive about the aesthetics aspects of the design. They can complain to the External Appearance Committee and try to influence its decision. This is correct and it's given 6 points. However, it's only a partial answer to the question. Question 4. The pre-sale of the houses is for Fondsbouw very disappointing. At this moment, the houses are not yet built. Fondsbouw wants to quit the project and sell its land to the municipality of A. An advisor of the municipality says that the municipality of A is not allowed to buy the land. The reason she gives is that the buildings that will be built eventually will become private property of the homeowners, and therefore no governmental interference is allowed. What is your opinion of this? Well, the argument is not valid for the Netherlands. The Netherlands, unlike Anglo-Saxon countries, does not maintain a strict division between public and private domains. Dutch municipalities are permitted to buy land on which private objectives, such as houses or offices, are planned. See the book section 5.2, no strict division between public and private domains, and section 5.4.1, ownership of real property for reasons. Alternative answers by students were as follows. If the answer implicates, without explicitly stating so, that the municipality is allowed to buy land, 3 points were given. The argument of the advisor is wrong, active land policy is very common and legally allowed in the Netherlands, is 9 points. So if your answer referred to the practice of active land development, that was very good as well. The final question is question 5. On another spot in the area, the municipality owns a storage yard. The land use objective for this area, according to the recently adopted land use plan, now is residential. The municipality wants to close the storage yard and sell the land. The municipality will enter into an agreement with the project developer who does the highest bid and meets some other requirements. Is this a public-private partnership? And if so, which model? Let's check the. Well, this is not a PPP. This is plain sale of land after a tender. We call this public land development, but public land development is not a partnership, not a public-private partnership. See the book section 5.5 on sale and section 5.7.4 on public-private partnership models. However, quite some students said if the municipality sells the land and it agrees with the buyer about certain conditions, it could be a concession. The conditions relate to the developer building roads, meets conditions regarding public spaces and amounts of social housing and so forth. Well, if you said that if the agreement is a concession, it is a PPP, that is correct. So you're correct if you stated that selling land together with quite some conditions, in that case, it can be seen as a public-private partnership model, specifically the concession. Okay, I'm satisfied with the answers that were given. The grades were quite good, so apparently this topic was well understood. Okay, this closes the answers to assignment Legal 1B.